Anything we need to take up before we bring jurors? No, sir. All right. Ms. D, are you comfortable where you're seated right now? You had brought up that issue.
Yeah. Yeah, we'll just scoot back.
We're fine. Thank you, Your Honor.
That's fine. All right, very good. If you'd bring jurors, please. Back, ladies and gentlemen. We are now ready for the final closing argument in this case, presented by Mr. Brown on behalf of the defense. Mr. Brown.
Thank you. Good afternoon. We are not here to decide whether the death of Melissa Huggins-Jones was horrible, tragic, and completely heartbreaking, because it was clearly all of that. And we're not here to decide whether Travion Smith broke into cars, sold a stolen computer, or was hanging around with Ronald Anthony. All of that happened, and none of it's ever been disputed. What we are here to decide is who is responsible for Melissa Huggins-Jones' death, and more specifically, has the state proven beyond a reasonable doubt that Travion Smith is guilty of first-degree murder. I'll take just a few moments to talk about the idea of beyond a reasonable doubt. It was a concept that we first started talking with most of you about during jury selection. It's a concept that is a basic principle in this country, and it goes with anyone charged with a criminal offense, whether it's running a stop sign or shoplifting. The state has the burden of proof, and they have to prove the case beyond a reasonable doubt. But it's really and especially important in a case like this, when the ramifications are so much, where it will mean either life imprisonment without parole or the death penalty. And what it simply means, when you boil it down to, when you get the instruction, is it's evidence that is so much that it fully satisfies or entirely convinces you of the person's guilt. And what it means is that there are some times that there are decisions in life that are so important and have such consequences that we hold people to that burden. And we don't want to make the decision unless we are fully satisfied and entirely convinced it's the right decision. And there's an analogy about that that I'd like to share with you. And it's one that, given the weather yesterday, I think has some bearing. Imagine a day like yesterday where it's so cold that you're near a pond, and the pond is covered with ice. And earlier in the day, you noticed that some people were wandering on the ice, skating on the ice, and taking advantage of the cold day. And you go out with your family, and you see how cold, that it's still really cold, and you see some animals on the ice. And so since you've seen people there, and you've seen animals, and it feels cold, it would seem to be safe to go on that ice. But when you look down you begin to see some cracks in the ice. You don't step on that ice. And you don't let your family step on that ice unless you are entirely convinced and fully satisfied that it's safe, that it's not going to cause harm. And that's the standard of care the law requires and that we request that you give in doing this case. That is beyond a reasonable doubt. One of the most critical things that your role is you are the ones who decide the witness's credibility. We're going to be talking about the credibility of people. And it's an interesting challenge because I think every day in life we have responsibilities to decide whether people are telling the truth or not. But a lot of times we have the advantage of doing that because we know the people, because we have advantages. Some of us have kids, some of us have siblings, and we begin to recognize people we know that well, different signs about whether they're telling the truth. The people who outside may not know, whether you can believe what they can say, whether you can trust what they say, the way they act, the way they say certain things. But we're not in that situation here because these are people that you have never seen before. Some of us are in situations where we've had co-workers or significant others or other people who we've determined over years, at first thinking that they were trustworthy, reliable, begin to later see that there are clues and hints that they are not so trustworthy. They're things that we look for and we realize that they cannot be believed. But even then, it's people because we've known something about them, you can tell. Here, as jurors, you are asked to decide the credibility of people who've come to the witness stand and to statements that you hear. And in making the determination about whether or not you can believe them, whether or not you can trust them, whether or not you can rely on them, you have to look at things beyond simply what they're saying on the stand. You have to look at the objective evidence. See, is this somebody you can trust? And it can include things like a person's criminal record, about what is their incentive for testifying and for making the statements, what is their mental health history. And in a few minutes, when Judge Ridgway gives his instructions, he's going to talk about how this is all things that you can and you should consider it. So it brings me to the first witness, and that is Melvin Brown. Melvin Brown is the only person in this case who says that Travion attacked Melissa Huggins-Jones, participated in her killing, and even puts him in the apartment. And you have to decide whether to give him any credibility and whether he is somebody worth believing, somebody worth trusting, somebody that you can rely on. And in doing it, I'm just going to talk a few moments about him, but I'm going to talk about Melvin Brown's criminal record. I am going to talk about the fact that he received substantial assistance and got a deal out of this. And I'm going to talk about the fact that he does have mental health issues, and all of them are relevant, and all should be part of your assessment of his credibility. Melvin Brown's criminal record, and I'm sorry if some of this is hard to see, but you see that he has been convicted 5 different times of felonies. And I think if you remember, if you go back to when Ms. Shakita was first examining him, and she said, well, you have a record, nothing violent. And he said, no, nothing violent. And then in cross-examination, you talk about the fact that he has a robbery causing serious injury. In 1998, he was convicted of conspiracy to distribute crack cocaine. 2000, he was selling drugs. 2005, selling drugs again, and now in 2014, convicted again of trafficking heroin. A person's criminal record is something that you can take in consideration, but there's twofold to take it in consideration here. Not only does it reflect on his trustworthiness, his credibility, his believability, but it also goes into the factor that he knew that he was facing these type of records when he was looking for a deal. in this case. This is what he was facing, trafficking in heroin. And it carries a minimum of 90 to 117 months in prison. 7.5 years to 9.5 years. It's not as long as what Mr. Smith is facing, but it's a long time in prison, and something that somebody would like to get their time less. The problem is this: despite that, not only does he have a terrible record, but his length of sentence can only be reduced if he provides the state with substantial assistance in some case. He chose not to give information about the heroin deals that he was involved in. That was not why he decided to go substantial assistance. He looked for another language. And he had been in the same cell block as somebody he knew was charged with murder. So here's the timeline of what events would happened with it. He was arrested January 3rd, 2014 and charged with trafficking heroin. So, on August 9th, 2014, he made a statement against Travion. He said that he had information saying that Travion was involved in this crime. Specifics. Did it help him? Was this just a worthless thing that was not going to amount? Well, 11 days later, he pled guilty to trafficking in heroin. And what he got was 70 to 93 months. What does that actually translate to? 2 years off of his sentence, simply by just going up to the police and making a statement against him. That's an incentive for somebody, the record of Melvin Brown, to come in there and make a statement about somebody. And then you saw, there was testimony, he was reluctant to testify, but he went in to testify. And what would be in it for him now to testify against Travion? He already got the 2 years off the sentence. Well, turns out he talked about that after the verdict, he might be applying for a motion for appropriate relief, depending on the results of this case, to see whether he can get his sentence, his time in prison, reduced even more. Receiving substantial assistance, what he knew was the only way to get out of prison, and we've already talked about, Melvin Brown has a lot of experience in the criminal justice system. And Melvin Brown is not going to think, you know, I'm in the same cell block as somebody charged with murder. Maybe I'll get substantial assistance if I talk about the fact that he maintained his complete innocence. You can get substantial assistance for saying the other guy is the one totally responsible. No, the only way Melvin Brown was going to get substantial assistance is if he said something that would implicate Travion Smith and that would help in his prosecution. That's the only way, and Melvin Brown knew that. So the question is not whether Travion and Melvin Brown were in the same cell block or talked about things, including his family, or different things about that. The question is, can you trust what he said now? Can you believe what he said now? Can you rely on what he said now? His mental health. And you're going to hear from Judge Ridgway, that is another thing you can take in consideration in deciding his truthfulness in this case. Melvin Brown suffers from a psychotic disorder. That affects his credibility. It requires antipsychotic medications, and Mr. Wallace said, we've been making a big deal that he suffered about it for many years. And it does matter that he's been suffering from this condition for years and years and was taking psychotic medications for 8 years prior to coming to the jail. It does matter that he is suffering from those conditions because it affects his credibility, and it should be considered by you. And he's hearing voices. This was something that he admitted and he acknowledged. While he is in the jail, he's heard these voices. And again, you have to make the decision. You have to judge a person's credibility. You have to use it based on objective factors. And the fact that Mr. Brown has this criminal record that he was getting a deal and doing it to get his time cut off from his sentence, and the fact that he has these mental health issues are all things that you should consider. You have to decide. Can you trust what he's saying? Can you believe what he's saying? Can you rely on what he's saying? Talk about Ronald Anthony. And there have been different statements that are going to be done throughout this entire case. You've heard different statements of him. And doing that, just like you can take into account the criminal record of Melvin Brown and other witnesses in deciding the credibility, you can take into account Ronald Anthony's credibility, his record. And we know that in September of 2015, he pled guilty to first-degree murder, and he received life imprisonment without parole. And all of that is relevant, and all of that can be taken into consideration when you decide the credibility of any statements that he made. The forensics or the physical evidence in this case, just going to talk briefly about that. I think Ms. D has talked more about that. But in this case, about evidence about Travion having broken into the apartment, about participating in the killing, you saw no evidence of any fingerprints. You saw no DNA. The footprints that they had, there was one in the house, but they never were able to match that with anybody because it got destroyed before they had a chance to analyze it. All the footprint evidence, shoe print evidence that they had was him outside of the apartment. There is no DNA linking Travion to this. There are no fingerprints linking him to it. So we talk about, Mr. Waller made a big deal that said, yes, Ronald Anthony is a murderer, but his degree of responsibility in this case shows that he is the one responsible for what happened to Ms. Huggins-Jones. He's the one. And what do we know about that? Some of the evidence, and I'm not going to go through every piece of evidence in here, but some of the evidence to point out is what Sarah Redden told you from the stand. When they got out in the car that night, who pulled out a knife? It was Ronald Anthony. Ronald Anthony pulled out the knife. It was in his possession, and he put it back in the knapsack. You heard no testimony from anybody, no evidence from anybody at all to suggest that anybody else ever had, that Travion at any point had a knife. It was only Ronald Anthony who had a knife. No evidence at all of Travion having any type of weapon that night. Only Ronald Anthony. And the clothing. Sarah talks about seeing specks of blood at the bottom of the shirt. And that was all. We saw no evidence at all of Travion Smith being covered with blood or about changing his clothes at any point. And she talked about seeing him standing next to him at the nightclub and all, but very specifically said he never changed his clothes. You saw the horrible and tragic and sad pictures of Melissa Huggins-Jones and how she was covered with blood and how blood was leaving everywhere. Travion Smith was involved in the killing. The way the state maintains he was involved in that killing, he wasn't going to be just having specks of blood on him. The blood would have been covered a lot more, and it couldn't have been simply wiped off like that. But Ronald Anthony? What do we know about Ronald Anthony? We know that the first thing he did was he
You
went...
keep your voice out.
I'm sorry.
Thank you.
We know the first thing that he did was he went and he changed out of his shirt, changed out of his clothing, he got new clothing before he went to the Flashdance strip club. That's the first thing that he did in that situation. And what happened after they got back from the motel? He ran. He went to his girlfriend's house, Amber Albert's house, and he took his clothing and he put it in the hamper and he began to wash it. There was no evidence at all that Travion Smith did anything like that with his clothing. In fact, the evidence all is that Travion Smith never even changed his clothes. And who was it that wrote a letter to Amber Alberts and said, get rid of the clothing? there was only one person who wrote such a letter. The one person who wanted to hide from the police the clothing because it was bloody, and that was Ronald Anthony, the person who was responsible for Melissa Huggins-Jones' death. What the hell just happened? It's a statement that they brought up that Sarah Redden says that Travion Smith said in the hotel. And it's one that Mr. Waller mentioned several times during his closing argument. And the argument is that it was some type of retrospective discussion about what are we all doing here and all. But I submit to you that when Travion Smith is saying, when anyone is saying what the hell just happened, it comes from somebody who is asking because they don't know what exactly just happened, how what happened, why what happened. We didn't hear, but what exactly was Ronald's response to it. But the statement itself, and everything indications, was more of somebody who was not involved in the killing, who did not see exactly what happened, who was not guilty of first-degree murder. Ronald Anthony's behavior before and after the crime suggests and helps prove that he is the one responsible for Melissa Huggins-Jones' death. Let's talk about before. Before the crime, and you can go back and you can even listen to, part of this is listen to what both Sarah Redden and Amber Albert said about Ronald Anthony. Particularly what Sarah said about the way how he was emotionally, physically, and mentally controlling, about how he would push her, hit her, leave bruises. And that evening, Ronald Anthony was clearly not only the leader, but the one who was more aggressive and was showing that he had a temper that both Sarah Redden and Amber Albert said he had. The temper, the only one you've heard about in the case, having that type of temper. And when you do that, keep in mind what happened in the Ben and Jerry's was one started about it at all. About how, yes, Sarah and Travion were being loud and rambunctious about talking about a application form, but nothing that would suggest a bad temper or just sort of loud goofiness. And when they were told to leave, they didn't cause any problems. It was Ronald Anthony who confronted them. Ronald Anthony, after that happened, who came out there and showed the anger, everything else. And when Sarah Redden talks about, and we all openly admit, and Travion admits in his statement, that they were all breaking into cars, but it was clear that night who was the leader, who was the one more bent on the criminal behavior. It was Ronald Anthony, and the one being the one who would pry open the fence to everything else, to taking control of everything else that had happened during that time. And Ronald Anthony's behavior after the crime showed that he was still the leader, still the one in the actions. It's not just what we talked about that we know that he's the one who had the knife. He's the one who had the bloody clothes. He's the one who went and sent the letter asking the stuff to be destroyed. It was that he was the one who arranged for the ride to be picked up. He also arranged for the ride, I forgot to mention beforehand, for all of them to be picked up in the first place. He's the one who did that. He's the one who said, we're going to flashbacks. Took him to the strip club and went in while Travion and Sarah stayed outside. He's the one who not only sold one of the laptops, but all the evidence was he's the one who was making the indications with Michael McCullum afterwards. He's the one who knew Michael McCullum, who contacted Michael McCullum, and was the one, until Travion ultimately sold it to him, who was arranging the entire deal. Everything about what happened afterwards points to the one responsible in this case as being Ronald Anthony. Talk a little bit about the verdict form. in this case, and you're going to be getting in a few moments, but you're going to have three choices. The first is that he be found not guilty, Travion Smith, of all charges in this case. And that's if the state has not proven to you beyond a reasonable doubt their case that he was involved in this killing. That's the one you should answer. There's also guilty of first-degree murder and guilty of second-degree murder. We're going to talk more in a few moments about what it means about guilty of first-degree murder. But guilty of second-degree murder would be where, no doubt about it, that Travion Smith would be punished, and the judge, but that will be up to the judge to determine how many years he will spend in prison if he's convicted of that. If it's not guilty, then the case is over and he goes home. If it's guilty of second-degree murder, then the judge decides what the appropriate sentence is based on the law. If it's guilty of first-degree murder, then it's between life imprisonment and the death penalty. You're going to be asked to just talk about, if you do decide first-degree murder, you're going to be talking about there are two options, and one of them is based on the felony murder rule, and the other conviction is based on malice, premeditation, and deliberation. I want to talk a little bit about each of those. Felony murder rule, three simple elements, and we talked about elements during jury selection. The defendant committed burglary, that while committing burglary, the defendant killed the victim, the defendant's acts was approximate cause of the victim's death. But that's the second one is the important thing, that the defendant, while committing burglary, they have to prove that he committed burglary. They have to prove that part beyond the reasonable doubt. Not that he was breaking into cars or other things, but that he went into Melissa Huggins-Jones' apartment with the intent to commit the burglary. And who, there's one, Sarah Redden does not put him in that apartment, she puts him on the balcony. Who is the only person who puts him in that apartment? Melvin Brown. And we've talked, and I'm not going to go into it all again, we've talked about the problems and why you can't trust Melvin Brown, you can't believe him, and you can't rely on what he has to say. They cannot show the burglary, you cannot convict Travion of first-degree murder under this. Premeditation and deliberation. And in doing that, it's simple. They have to go ahead and show that there was a plan, that there was deliberation, and there was a specific intent to kill. And you heard Sarah Redden's testimony, you heard the interview with Travion, and at no point is there any talk of them or any evidence from anybody there was ever any talk at that night of assaulting anybody, of hurting anybody. There certainly was never any discussion of killing anybody. They did not know that was the plans of anybody, and it was not the plans of anybody. Mere presence. You're going to hear those words from Judge Ridgway. Is not guilty of a crime merely because the defendant is present at the scene, which simply means this. If just the fact that he was around that apartment complex, even if you believe that he was at the balcony, even if you believe, if he did not actually, if they cannot prove that he broke into that apartment, and that he is not guilty simply because of his presence, he's also not guilty because he broke into cars, or any other activity, criminal activity that you believed occurred before or afterwards. They have to prove beyond a reasonable doubt that Travion Smith was involved in the burglary and wasn't really present. In the end, you are the ones who evaluate all the evidence, the credibility of all the witnesses, and You've heard a lot of evidence over the last 2 weeks, but you have to decide the facts more than the emotion of the horribleness of the crime, more than speculation. You have to decide whether they've proved to you that they have entirely convinced and fully satisfied you of the guilt. And in this case, they have not done so. They cannot do so, for as hard as they try. Travion Smith is not guilty of first-degree murder, and you should not find him guilty of first-degree murder. Thank you.
Thank you, Mr. Brown. So, ladies and gentlemen, in a moment I'm going to read the jury instructions to you. I'm going to ask the bailiff to distribute printed copies of those jury instructions to you to read along with me. I ask that you not read ahead. These instructions will be yours to keep, so you can mark on them. You can take them back into the deliberation room as you deliberate on this case. So, bailiff, you'll go ahead and distribute those to the jurors. Bailiff. Thank you, sir. All right, members of the jury, all of the evidence has been presented, and it's now your duty to decide from this evidence what the facts are. You must then apply the law that I'm about to give to you to those facts, and it's absolutely necessary that you understand and apply the law as I give it to you, not as you think it is or might like it to be. This is important because justice requires that everyone tried for the same crime be treated the same way and have the same law applied. The defendant has entered a plea of not guilty. The fact that the defendant has been charged is no evidence of guilt. Under our system of justice, when a defendant pleads not guilty, the defendant is not required to prove the defendant's innocence. The defendant is presumed to be innocent. The state must prove to you that the defendant is guilty beyond a reasonable doubt. A reasonable doubt is a doubt based on reason and common sense, arising out of some or all of the evidence that has been presented, or the lack or insufficiency of the evidence, as the case may be. Proof beyond a reasonable doubt is proof that fully satisfies or entirely convinces you of the defendant's guilt. You are the sole judges of the believability of witnesses. You must decide for yourselves whether to believe the testimony of any witness. You may believe all, any part, or none of a witness's testimony. In deciding whether to believe a witness, you should use the same tests of truthfulness that you use in your everyday lives. Among other things, these tests may include the opportunity of the witness to see, hear, know, or remember the facts or occurrences about which the witness has testified, the manner and appearance of the witness, any interest, bias, prejudice, or partiality the witness may have, the apparent understanding and fairness of the witness, whether the testimony is reasonable, and whether the testimony is consistent with other believable evidence in this case. You are the sole judges of the weight to be given to any evidence. If you decide that certain evidence is believable, you must then determine the importance of that evidence in light of all other believable evidence in this case. There are two types of evidence from which you may find the truth as to the facts of a case. There's direct evidence and circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain or group of facts and circumstances indicating the guilt or innocence of a defendant. The law makes no distinction between the weight to be given either direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should weigh all the evidence in this case. After weighing all the evidence, if you are not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. You may find that a witness is interested in the outcome of this case. You may take the witness's interest into account in deciding whether to believe the witness. If you believe the testimony of the witness in whole or in part, you should treat what you believe the same as any other believable evidence. You may find that a witness was an accomplice in this case. An accomplice is a person who joins with another in the commission of a crime. The accomplice may take part in acts necessary to accomplish the crime, or may knowingly help another in the crime, either before or during its commission. The law considers an accomplice to have an interest in the outcome of the case. If you find that a witness was an accomplice, you should examine every part of the testimony of the witness with the greatest care and caution. After doing so, if you believe the testimony in whole or in part, you should treat what you believe the same as any other believable evidence. You may find that a state's witness is interested in the outcome of this case because of the witness's activity as an informer. If so, you should examine the testimony of the witness with care and caution. After doing so, if you believe the testimony in whole or in part, you should treat what you believe the same as any other believable evidence. Evidence has been received concerning a mental health disorder of a witness. You may consider this evidence for one purpose only. If, considering the nature of the mental health disorder, you believe that this bears on the witness's truthfulness, then you may consider it, together with all other facts and circumstances bearing on the witness's truthfulness, in deciding whether you will believe or disbelieve the witness's testimony at this trial. You may not consider this evidence for any other purpose. Evidence has been received tending to show that at an earlier time a witness made a statement which may conflict with or be consistent with the testimony of the witness at this trial. You must not consider such earlier statement as evidence of the truth of what was said at that earlier time, because it was not made under oath at this trial. If you believe the earlier statement was made and that it conflicts with or is consistent with the testimony of the witness at this trial, you may consider this, along with all other facts and circumstances, bearing on the witness's truthfulness in deciding whether you will believe or disbelieve the witness's testimony. Evidence has been received concerning criminal convictions of a witness. You may consider this evidence for one purpose only. If, considering the nature of the crimes, you believe that this bears on the witness's truthfulness, then you may consider it, together with all other facts and circumstances bearing upon the witness's truthfulness in deciding whether you will believe or disbelieve the witness's testimony at this trial. You may not consider this evidence for any other purpose. Photographs and diagrams were introduced into evidence in this case for the purposes of illustrating and explaining testimony of witnesses. These photographs and diagrams may not be considered by you for any other purpose. Certain photographs, namely Exhibit 233, a photograph of a dryer vent with a scale, Exhibits 238 through 239, 243 through 359, and 369 through 383, all of which purported to be shoe impressions, Exhibit 387 through 405, which purport to be photographs from the autopsy of Melissa Huggins-Jones, and video evidence were introduced into evidence in this case. These photographs and video evidence may be considered by you as evidence of facts that they illustrate or show. If you find from the evidence that the defendant has admitted a fact relating to the crime charged in this case, then you should consider all the circumstances under which it was made in determining whether it was a truthful admission and the weight that you will give to it. Evidence has been received tending to show that on a date prior to May 14, 2013, the defendant and others participated in breaking and entering into motor vehicles. This evidence was received solely for the purpose of showing that there existed in the mind of the defendant a plan, scheme, system, or design involving the crime charged in this case. If you believe this evidence, you may consider it, but only for the limited purpose for which it was received. You may not consider it for any other purpose. And let me go back and clarify that first sentence. Evidence has been received tending to show on a date prior to May 13 and 14, 2013, the defendants and others participated in breaking and entering into motor vehicles. If you'll make that amendment to the written instructions that you have in front of you. In this case, you've heard evidence from witnesses who have testified as expert witnesses. An expert witness is permitted to testify in the form of an opinion in a field where the witness purports to have specialized skill or knowledge. As I've instructed you, you are the sole judges of credibility for each witness and the weight to be given to the testimony of each witness. In making this determination as to the testimony of an expert witness, you should consider, in addition to the other tests of credibility and weight, the witness's training, qualifications, and experience or lack thereof, the reasons, if any, given for the opinion, whether the opinion is supported by facts that you find from the evidence, whether the opinion is reasonable, and whether it is consistent with other believable evidence in the case. You should consider the opinion of an expert witness, but you are not bound by it. In other words, you are not required to accept an expert witness's opinion to the exclusion of the facts and circumstances disclosed by other testimony. Evidence has been received from a witness in the form of an opinion. You may only consider the opinion of a witness that is rationally based on the perception of the witness and helpful to a clear understanding of the witness's testimony or the determination of a fact in issue. The defendant in this case has not testified. The law gives the defendant this privilege. This same law also assures the defendant that this decision not to testify creates no presumption against the defendant. Therefore, the silence of the defendant is not to influence your decision in any way. I instruct you that the state has the burden of proving the identity of the defendant as the perpetrator of the crime charged beyond a reasonable doubt. This means that you, the jury, must be satisfied beyond a reasonable doubt that the defendant was the perpetrator of the crime charged before you may return a verdict of guilty. The defendant has been charged with first-degree murder. Under the law and evidence in this case, it is your duty to return one of the following verdicts. Number 1, guilty of first-degree murder, or number 2, guilty of second-degree murder, or number 3, not guilty. You may find the defendant guilty of first-degree murder either under the first-degree felony murder rule or on the basis of malice, premeditation, and deliberation, or both. First-degree murder under the first-degree felony murder rule is the killing of a human being in the perpetration of a burglary. First-degree murder on the basis of malice, premeditation, and deliberation is the intentional and unlawful killing of a human being with malice and with premeditation and deliberation. Second-degree murder is the unlawful killing of a human being with malice but without premeditation and deliberation. In the event that the defendant is convicted of murder in the first degree, the court will conduct a separate sentencing proceeding to determine whether the defendant should be sentenced to death or life imprisonment without parole. If that time comes, you will receive separate sentencing instructions. However, at this time, your only concern is to determine whether the defendant is guilty of the crime charged or any lesser included offense about which you are instructed. For you to find the defendant guilty of first-degree murder under the first-degree felony murder rule, the state must prove 3 things beyond a reasonable doubt. First, that the defendant or a person with whom the defendant was acting in concert committed burglary. Burglary is the breaking and entering in the nighttime of another person's occupied dwelling house or apartment without that person's consent and with the intent to commit larceny. To establish the first element, the state must prove 5 things beyond a reasonable doubt. Number 1, that the defendant or a person with whom he was acting in concert broke and entered a dwelling house or apartment. Number 2, that the breaking and entering was during the nighttime. Number 3, that at the time of the breaking and entering of the dwelling house, at the time of the breaking and entering, the dwelling house or apartment was occupied. Number 4, that the owner or tenant did not consent to the breaking and entering. And number 5, that at the time of the breaking and entering, the defendant or the person with whom he was acting in concert intended to commit larceny within the dwelling house or apartment. Larceny is the taking and carrying away of another person's property without the victim's consent, knowing that he was not entitled to take it and intending at that time to deprive the victim of its use permanently. The second element the state must prove beyond a reasonable doubt to establish felony murder is that while committing the burglary, the defendant or a person with whom the defendant was acting in concert killed the victim. And third, that the defendant's act or the act of the person with whom the defendant was acting in concert was a proximate cause of the victim's death. A proximate cause is a real cause, a cause without which the defendant's death would not have occurred. There is a principle in our law known as acting in concert. For a person to be guilty of a crime, it is not necessary that he personally do all the acts necessary to constitute the crime. If two or more persons join in a common purpose to commit burglary, they are said to be acting in concert. Each person acting in concert, if actually or constructively present, is not only guilty of that crime if the other person commits the crime, but also guilty of any other crime committed by the other in pursuance of the common purpose to commit burglary or as a natural or probable consequence thereof. A defendant is not guilty of a crime merely because the defendant was present at the scene, even though the defendant may silently approve of the crime or secretly intend to assist in its commission. To be guilty, the defendant must aid or actively encourage the person committing the crime or in some way communicate to another person the defendant's intention to assist in its commission. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant acting either by himself or acting together with other persons committed burglary, that while committing burglary, the defendant or someone with whom he was acting in concert killed the victim, and that the defendant's act or the act of someone with whom the defendant was acting in concert was the proximate cause of the victim's death, it would be your duty to return a verdict of guilty of first-degree murder under the felony murder rule. If you do not so find or have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of first-degree murder under the felony murder rule. Whether or not you have found the defendant guilty of first-degree murder under the felony murder rule, you will consider whether the defendant is guilty of first-degree murder on the basis of malice, premeditation, and deliberation. The unlawful killing of a human being with malice and with premeditation and deliberation is first-degree murder. For you to find the defendant guilty of first-degree murder on the basis of malice, premeditation, and deliberation, the state must prove 5 things beyond a reasonable doubt. First, that the defendant or a person with whom the defendant was acting in concert intentionally and with malice killed the victim. Malice means not only hatred, ill will, or spite as it is ordinarily understood. To be sure, that is malice. But it also means the condition of mind which prompts a person to take the life of another intentionally, or to intentionally inflict serious bodily harm, which proximately results in another person's death without just cause, excuse, or justification. If the state proves beyond a reasonable doubt that the defendant or a person with whom the defendant was acting in concert intentionally killed the victim with a deadly weapon, or intentionally inflicted a wound upon the deceased with the deadly weapon that proximately caused the victim's death, you may infer first that the killing was unlawful, and second, that it was done with malice, but you're not compelled to do so. You may consider this along with all other facts and circumstances in determining whether the killing was unlawful and whether it was done with malice. A deadly weapon is a weapon which is likely to cause death or serious injury. In determining whether fists or other blunt objects is a deadly weapon, you should consider its nature, the manner in which it was used, and the size and strength of the defendant compared to the victim. A knife is a deadly weapon. Second, the state must prove that the defendant's act or the act of a person with whom the defendant was acting in concert was a proximate cause of the victim's death. A proximate cause is a real cause, a cause without which the victim's death would not have occurred. Third, that the defendant or a person with whom the defendant was acting in concert intended to kill the victim. Intent is a mental attitude seldom provable by direct evidence. It must ordinarily be proved by circumstances from which it may be inferred. An intent to kill may be inferred from the nature of the assault, the manner in which it was made, and the conduct of the parties and other relevant circumstances. Fourth, that the defendant or a person with whom the defendant was acting in concert acted with premeditation, that is, that the intent to kill the victim was formed over some period of time, however short, before the defendant or the person with whom the defendant was acting in concert acted. And fifth, that the defendant or a person with whom the defendant was acting in concert acted with deliberation, which means that it was done, that the act was done in a cool state of mind. This does not mean that there had to be a total absence of passion or emotion. If the intent to kill was formed with a fixed purpose, not under the influence of some suddenly aroused violent passage, it is immaterial that the defendant or a person with whom the defendant was acting in concert was in a state of passion or excited when the intent was carried into effect. Neither premeditation nor deliberation is usually susceptible to direct proof. They may be proved by proof of circumstances from which they may be inferred, such as the lack of provocation by the victim, conduct of the defendant before, during, and after the killing, use of grossly excessive force, infliction of lethal wounds after the victim is felled, brutal or vicious circumstances of the killing, and the manner in which or means by which the killing was done. Again, I instruct you on the principle in our law known as acting in concert. This principle applies here as well. For a person to be guilty of a crime, it is not necessary that he personally do all of the acts necessary to constitute the crime. If two or more persons join in a common purpose to commit burglary, they are said to be acting in concert. Each person acting in concert, if actually or constructively present, is not only guilty of that crime if the other person commits the crime, but also guilty of any other crime committed by the other in pursuance of the common purpose to commit burglary, or as a natural or probable consequence thereof. A defendant is not guilty of a crime merely because the defendant is present at the scene, even though the defendant may silently approve of the crime or secretly intend to assist in its commission. To be guilty, the defendant must aid or actively encourage the person committing the crime, or in some way communicate to another person the defendant's intention to assist in its commission. If you find from the evidence beyond a reasonable doubt that on or about the alleged date the defendant acting either by himself or with someone with whom the defendant was acting in concert with malice killed the victim, thereby approximately causing the victim's death, that the defendant or someone with whom the defendant was acting in concert intended to kill the victim, and that the defendant or someone with whom the defendant was acting in concert acted after premeditation and with deliberation, it would be your duty to return a verdict of guilty of first-degree murder on the basis of malice, premeditation, and deliberation. If you do not so find or have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of first-degree murder on the basis of malice, premeditation, and deliberation. If you do not find the defendant guilty of first-degree murder under either the felony murder rule or on the basis of malice, premeditation, and deliberation, you must determine whether the defendant is guilty of second-degree murder. If you do find the defendant guilty of first-degree murder under either the felony murder rule or on the basis of malice, premeditation, and deliberation, or both, you will not determine whether the defendant is guilty of the offense of second-degree murder. Second-degree murder is the unlawful killing of a human being with malice but without premeditation and deliberation. Second-degree murder differs from first-degree murder in that neither specific intent to kill, premeditation, or deliberation is a necessary element. For you to find the defendant guilty of second-degree murder, the state must prove beyond a reasonable doubt that the defendant or someone with whom he was acting in concert unlawfully, intentionally, and with malice wounded the victim, thereby approximately causing her death. If the state proves beyond a reasonable doubt that the defendant or someone with whom the defendant was acting in concert intentionally inflicted a wound upon the victim that proximately caused the victim's death, you may infer first that the killing was unlawful and second that it was done with malice, but you are not compelled to do so. You may consider the inferences along with all other facts and circumstances in determining whether the killing was unlawful and whether it was done with malice. If the killing was unlawful and was done with malice, the defendant would be guilty of second-degree murder. Again, for a person to be guilty of a crime, it's not necessary that he personally do all the acts necessary to constitute the crime. If two or more persons join in a common purpose to commit burglary, they are said to be acting in concert. Each person acting in concert, if actually or constructively present, is not only guilty of that crime if the other person commits the crime, but also guilty of any other crime committed by the other in pursuance of the common purpose to commit burglary, or as a natural or probable consequence thereof. A defendant is not guilty of a crime merely because the defendant is present at the scene. even though the defendant may silently approve of the crime or secretly intend to assist in its commission. To be guilty, the defendant must aid or actively encourage the person committing the crime or in some way communicate to another person the defendant's intention to assist in its commission. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant acting either by himself or with someone with whom the defendant was acting in concert, intentionally and with malice wounded the victim, thereby approximately causing the victim's death, it would be your duty to return a verdict of guilty of second-degree murder. If you do not so find or have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. The verdict form sets out first-degree murder both on the basis of malice, premeditation, and deliberation, and first-degree murder under the felony murder rule and second-degree murder on the basis of malice but without premeditation and deliberation. In the event that you should find the defendant guilty of first-degree murder, please have your foreperson indicate whether you did so on the basis of malice, premeditation, and deliberation, or under the felony murder rule, or both. Now, members of the jury, you've heard the evidence and the arguments of counsel. If your recollection of the evidence differs from that of the attorneys, you are to rely solely upon your own recollection. Your duty is to remember the evidence whether it is called to your attention or not. You should consider all of the evidence, the arguments, contentions, and positions urged by the attorneys, and any other contention that arises from the evidence. The law requires the presiding judge to be impartial. You should not infer from anything that I have done or said that the evidence is to be believed or disbelieved, that a fact has been proved, or what your findings ought to be. It is your duty to find the facts and render a verdict reflecting the truth. All 12 of you must agree to your verdict. You cannot reach a verdict by majority vote. When you have agreed upon a unanimous verdict, your foreperson should so indicate on the verdict form. After reaching the jury room, your first order of business will be to select your foreperson. You may begin your deliberation when the bailiff delivers the verdict form to you. Your foreperson should lead the deliberations. When you have unanimously agreed upon your verdict and are ready to announce it, your foreperson should record your verdict, sign and date the verdict form, and notify the bailiff by knocking on the jury room door. You'll be returned to the courtroom and your verdict will be announced. Now, ladies and gentlemen, you've heard me mention the verdict form. This is the verdict form. It will be sent back to you in this envelope shortly after you retire to begin your deliberations. Again, when you reach the jury room in a few moments, I'll ask that you simply select your foreperson and then wait until you receive this packet. That will be your signal to begin your deliberations. The verdict form is self-explanatory. It has the offenses that I've described, first-degree murder, second-degree, or not guilty. It has the two options for first-degree murder and a place for you to indicate, if you do find the defendant guilty of first-degree murder, a place for you to indicate which theory, one, either, or both, that you've used. It also has instructions that guide you through that process. Also contained in this packet is a pad of paper and a pen. In the event during your deliberations you have any questions of the court, any requests of the court, the way you let us know that is by writing your question or request on a slip of paper, summoning the bailiff by knocking on the jury room door. The bailiff will bring me your question or request, and I'll discuss with counsel how best we can respond to it, and we'll bring you back in the courtroom to respond to it. It may be something as simple as you're requesting a break or writing supplies or anything of that nature. It could be any other question or request that you have in the process of your deliberations. Now, with respect to our 3 alternate jurors, it appears that the original 12 jurors are in a position to deliberate, and so with respect to the 3 of you, I'm going to ask, first of all, I can release you for the day at least, and so I'm going to give you further instructions, but I can release you and allow these 12 jurors to deliberate this matter. What I'd like to do first, though, is to make sure that you don't have any personal belongings in the deliberation room that you need to retrieve. If you do, let's go ahead and take care of that now. Bailiff, if you'll accompany any jurors who have personal belongings they need to retrieve. Just leave those there. All right, so at this time, I'm going to ask the original 12 jurors to go ahead and go to the deliberation room. You may take your notebooks with you as well as the printed copy of the instructions I've just read to you. Again, select your foreperson. When you receive this packet, this will be your signal to begin your deliberations. So if you'll three jurors will just stand aside so these original jurors can go to the deliberation room. I'll have very brief instructions for you after they leave. All right, so for our three alternate jurors, as you know, we're very grateful for your service, and I can release you for the day. As you know, that there, depending on the outcome of this first phase, there may be another phase of this trial, in which case we will require your continued service. But I can release you to go about your business for the day or until we summon you. There's no prediction of how long a jury deliberates, so that may be hours, it may be days. We really have no way of knowing. But once we reach that point, we will contact you again to let you know whether your services are continued to be needed, and if they are, give you a time to report. If they're no longer needed, then of course it would be with our great thanks and appreciation. The rules that I've been reciting to you continue to apply. It's very important that you not discuss this case with anyone or allow anyone excuse me, to discuss it in your presence, that you not conduct any independent research into these matters or read, view, or listen to any media accounts of this matter, that you not have any communications with parties, witnesses, or lawyers, and it's important that you not form or express opinions about this case. So with all of that being said, we thank you. I would ask that you leave your materials in your chair. We will safeguard those for you so that if there are further need for you, we will have those available for you for your continued participation in this matter. But with the great thanks of the court, we can release you at this time to go about your business. Thank you. Yes, go ahead and give your badges to the bailiff, and we'll reissue those badges. That's fine, just leave them in your chair. We'll reissue those badges if and when we call you back.
Thank you, Your Honor.
Thank you, sir. All right, counsel, outside the presence of the jury, are there any corrections or objections to the jury instructions as they were read?
No, sir, none of that was said.
Nothing other than repeats.
All right, and you have all had the opportunity to review the form of the verdict. Any objection to the verdict sheet and its form?
Yes, sir. No objection.
All right, very good. I'm going to ask the bailiff to deliver the verdict packet to the jurors. All right, this court will stand at ease while the jury deliberates. What I'll ask counsel to do is remain close by in the event that we have question or a verdict so that we can quickly gather and address any concerns of the jury.
This court stands at ease.
Oh, okay. Okay.